So, what is a grievance? Well, the use of the word grievance in everyday language is different than a technical grievance in the context of a collective bargaining agreement. So, when an employee alleges that there's a violation of the collective bargaining agreement, a grievance is a process for following through on that allegation. Now, it has to be specifically a violation of the contract, a violation of the collective bargaining agreement. There can be many different concerns that employees have about how they're being managed, how they're being treated at work, and they might be valid complaints, but if they're not covered in the collective bargaining agreement, then it's a gripe. It's a concern which the union has limited ability to address. But when we're talking about a grievance, a violation of the collective bargaining agreement, the union has a recourse for addressing those concerns, and it is the duty of the union to defend that collective bargaining agreement against violations, and those may be violations that are seen by employees, and a grievance is a process by bringing that complaint, that formal complaint of a contract violation forward. Now, there's real advantages to having a process that immediately gets things into writing, and certainly written grievances are necessary for them to be deliberated by management and unions and come to some resolution. And again, a grievance is a violation of a written document, the collective bargaining agreement, the contract. And so it's very useful to be able to point to the language in the contract that is being violated. And so you need that to be written out. But there are other advantages. It also provides a written record that can be looked at when you start negotiating, because it clearly might be some misunderstanding between employees and management in terms of something in the contract. And it might be something that needs to be addressed, and having that record might make it more likely that it is addressed the next time the contract is negotiated. Also, when you get things down in writing, it takes time to get the writing clear. It can, through that process, dampen some of the strong feelings that people have, and lend concerns more towards a rational discussion of what the problem is. Also, it is a formal process, and so if an employee, has a complaint, then it's a way for them to step forward. But then again, they have to formalize that and put it in writing, and some might be apprehensive to do that. Again, if it's a violation of the contract, the union should defend it, but you need to have someone who's being represented to step forward and say that, yes, this is a violation. And again, there's lots of different complaints that people can have, and there can be different perceptions of violations of the contract, and there are limited resources to address them. Now, it's again the obligation of the union to represent people, and it's the obligation of management to abide by a collective bargaining agreement that is signed. By formalizing the process, though, it makes people go through it who are clearly serious about their perception of a grievance. And petty concerns that people have, or minor concerns that people have, oftentimes will be worked out informally. And so overall, we can reduce the number of grievances filed. Now, often we have to, when we're leading in a union, and I've had this experience when people come to me with grievances, you have to go through and talk them through the difference between a grievance and a gripe. And you have to figure out what the situation is. And it's very useful, I find, to not jump to conclusions. So taking up an approach that is supportive yet investigatory is very useful. It's find out, what are the perceptions of this person? Why do they feel that they have a grievance? and explore the situation, and then also explore if there are connections to the contract. And so I think it's good to start just by listening and let people air their concerns and get the facts out. But eventually you have to get to the kind of the legal question of, is there a violation in the contract? And it helps again to have fully listened to the situation, because we don't want to jump to conclusions. And by getting all the information out, it can help us make a better decision of whether this is truly a grievance, where it is a violation of a legal contract, or is it more so a gripe that the union has more limited ability to address, but maybe we can help to address it informally. So typically collective bargaining agreements are, there's lots of territory for the violation of a contract. And some of those things could be administrative in nature, like who gets a promotion, or what type of work is a person assigned, or are health and safety rules being followed. Of course, bargaining unit members often have their eye on economic issues, and so are they getting the appropriate wages? Are they getting the overtime that's agreed to? Is there some kind of benefits that are tied to the contract? And then finally, of course, oftentimes there are concerns about discipline. And many times when employees are disciplined, there is just an immediate reaction to grieve that. And so we need to be prepared to look at, were the rules applied reasonably? What is the process that was gone through? Was there the due process that's specified specifically in the contract? Was it followed? And so lots of different issues that could be the subject of grievances. Again, the main reason people file grievances is because they feel they've been wronged. And again, the question is it a wrong that violates the contract? Or is it something else that still may be wrong, but the union is not there to protect every wrong. It's there to protect the collective bargaining agreement. So we see that people who file grievances tend to be younger. They tend to be more active in the union. They tend to be less satisfied with their job and less satisfied with the supervisor. And it's interesting, they say they're less satisfied with the union. They may, in ways, be pushing the union to represent them. People who grieve may be generally unsatisfied, and that's where gauging whether there's a real violation of the contract is very important. But again, if we have people who are dissatisfied with the union, a good way to win their satisfaction is to do good work for them. So the research in the book also describes why people file grievances. And of course, it has to be that there's a perceived contract violation, because that's definitionally what a grievance is. But also, again, people are taking on a kind of a burden by doing a grievance, and they do it for a reason, because they want to draw attention to a problem, because they want perhaps some status in the organization, in the union. Um, and there may be some times where people just, they want to complain to get something, and that's something where we have to look at each grievance and determine its merits. Now, there's real significance to grievances. If we're looking at non-union firms and we see that there are a lot of complaints about how people are being managed, that is a recipe for an organizing drive for a union. Now, one way to avoid that is to use alternative grievance procedures. You could say, hey, we're going to set up a process where you can file a grievance and you don't need a union. And in that way, that might be a win-win for the organization and the employees, because they can address their concerns, but not have to pay union dues, and for the management not have to be controlled in so many other ways. Now, clearly, the process of filing grievance is more systematic in a union firm. And it's very important that unions take this seriously because, again, this is one of their main functions. They have a duty to represent employees with regard to the contract, but it also affects the perceptions of the union to those that are being represented, those employees in the bargaining unit. And there can be positives out of this in that it provides information about organizational conflict. It provides an orderly way to address that conflict. And it provides a mechanism for people with less power to communicate with those who have more power in the organization. And so it can be a way of finding corrective action for an organization. Now, whether you're management or whether you're union representing an employee with regard to a grievance, it's important that you do your homework. And so this slide describes the essential steps that either management or union needs to do when they are in a situation of handling a grievance. Of course, it's important that you have the facts, and so you got to gather the evidence, the who, the what, the where, the when. Okay, all of those questions that can give us facts and help us to substantiate them, and then also gauge their accuracy, their reliability. And by looking at the situation, when was it, who was there, talking to everybody, we can determine if the facts are reliable and consistent. In doing so, we can frame an argument about the situation. Obviously, if you're coming at this from the perspective of management, it's very different than from the union. But it's important nonetheless, whichever perspective, to work within the facts, to frame your arguments within the facts. In terms of framing your argument, it's important that it tells a logical story, that there is a consistency and a coherence to those facts, and that there is a believability, a credibility to the facts that are presented. Now, telling the truth is good, but it's not often enough. Some people have anxiety issues. Some people are not in a situation where they're good witnesses, not because they're not telling the truth, but because they're nervous or for some other reason. And so it's important that we prepare witnesses and ensure that they are telling the truth and that they're communicating clearly. We also, whether we're management or union, have to prepare for disagreement. The other side might say that, hey, these facts shouldn't be admitted because they're not relevant, or they might make counter arguments to the facts that you have to defend your position. And so it's important to not only prepare your own arguments, but also prepare and anticipate for the arguments of the other side and how you're going to counter those arguments. One thing the union legally can do is to get and gather information about the grievance. And there's many different kinds of records, and we live in a very information rich world. And so it might be accident records, it might be notes from a meeting, it might be other types of organizational records like job assignments or job descriptions, payroll records. Um, each situation is going to lend itself to a different set of relevant sources, but it's good to understand that we need to have access, and through the process should be ensured access to relevant information to have deliberation about the grievance.